So in a previous episode, if we're calling these episodes, we covered off a little bit about trademarking. So I suppose following on from that, should you trademark your logo, your name, both? What are your thoughts on that?
Yeah, it is a very important consideration. Trademarking your brand is essential, but you're absolutely right. There are two ways you can do it, or you can do it both ways.
Yeah.
One option is you register the words that are your business name.
Yeah.
So if you are Joe Bloggs Plumbing, you would be trying to register the words Joe Bloggs Plumbing as a trademark in a relevant class.
Which I assume could have its pitfalls if it's quite common.
Which,
yeah,
there are loads of pitfalls in it. But that's ideally what you want to aim for. Your other alternative is that if you've developed a logo, let's say it's a very distinctive device that's got maybe Joe Bloggs written in the middle of it, do you take that device, that image, and apply to register that? In an ideal world, you would do both of those.
Yeah.
I personally think that the strongest trademark protection you get is from registering the name of the brand as a word mark.
Yeah.
Ideally, you would also register a device. But just as you say, it is very common that when you come to register a trademark, you find somebody's already got it, or they've got something very similar to it, which prevents you from registering it. So in a worst case scenario, in some cases, we proceed with registering just the distinctive logo and then wait until there's sufficient knowledge and awareness in the market of that brand, and then you can go back to try and register the name.
Yeah.
But the name is the most important thing to register.
Okay. And just thinking on names, slightly different topic, but when franchisees are registering their business names, would you ever have the franchise or brand name within their name as a trading as or any such description?
Yeah, I mean, this topic, this question gets asked to me a lot of the time, and you can understand the logic. A franchisor, if they're appointing franchisees in Sussex, in Surrey, in Suffolk, they're going to want to call them the franchisee Joe Bloggs Surrey, Joe Bloggs Sussex, Joe Bloggs Suffolk Limited in each case. But there's one big reason why you don't want that to happen. It's because if that franchisee goes bust or gets sued in relation to a matter that may have nothing to do with you, your Joe Bloggs brand name is going to be plastered all over the court papers and therefore can get into the press. And it can be very, very detrimental to the brand. So it's then better for the franchisee to register any bland random company name that doesn't have your brand name in it, because your brand is the thing that you're selling under this franchise. You need to protect it. And once the franchisee has registered a limited company with your name in it, you can't control what they're doing with that limited company. So in an ideal world, you want your franchisees to pick random, nondescript trading limited company names, and then at the end they add the words trading as Joe Bloggs Plumbing or whatever it is.
But is that trading as written onto the company name, or is that just on paperwork that might be going on?
Yeah, good question. It's on the paperwork. It's on signage. It can be on invoices. It can be on quotes, but it's not part of their company name.
Fine. Okay.